Okay, Ms. Perry, anything that you wanted to say today?
I apologize for my actions, and you really do need treatment that would be beneficial for me. I've never been a separate I've never had any skills or anything to be sober. Thank you.
Okay. All right. I did read through the report. I'm familiar with what happened in both of these circumstances. Obviously, you were intoxicated in both situations, created a lot of problems that didn't need to happen. The incident at Timothy's, all you had to do was just leave, just walk out the door. Police never would have even been called. And even when the police were there, all you had to do was just leave, walk out the door. You wouldn't be standing here today. And your interactions with them, you know, you were intoxicated, but that's and that's no excuse for treating other people the way you're treating the officers there that night. Then the second incident, clearly also intoxicated. Nobody would try to do what you were doing if you weren't under the influence swimming across the lake. Your significant other had to call the police because he was worried that you were going to drown, tying up resources that could have been used much more effectively. You know, our budgets in this county are already up against the wall. We don't need police officers and EMS taking their time to respond to somebody who's intoxicated and trying to swim across Otsego Lake. And then, of course, your actions in resisting the officers. Mr. Gill is right. I mean, there wasn't a whole lot of physical resistance in either of these incidents, but certainly your actions took up way more of the officer's time than needed to be taken up, and both just completely unnecessary uses of resources to attend to someone who's getting intoxicated and not able to control himself. And so I think there needs to be a greater penalty than you had last time. I think Mr. Roll is absolutely right. It doesn't make sense for you to continue to engage in the same behavior over and over again and treat it the same way or with less of a penalty. I think you do need treatment. I don't think you need to wait for the court to order that. That always surprises me when people are aware they have a problem. They know that there's treatment available, but it's like, no, I want the court to order me to do it. You can do it on your own. Nobody has to tell you to do it. And if you want to continue to avoid spending time in jail, it's going to be in your best interest to seek out those resources and get the help that you need on your own. Because your guidelines here call for up to 28 months in prison. And the next time you get in trouble, you're probably not going to have a lower end in county. It's going to be prison, and that's it. So I really think this is your last chance to avoid going to prison. And so if you want to do that, I think you need to take the steps yourself to get the treatment that you need to work on this issue so that you don't put yourself in this position anymore. But at this point, I think straight jail is appropriate given your history and given your behavior in both of these incidents. And I think a sentence within the guidelines is appropriate, but certainly higher than your previous case. So the court finds that 9 months as to each charge is an appropriate sanction. I think that addresses your conduct in this case as well as your previous history. So in each file, 236616 and 236617, the court is going to sentence you to 9 months in the Otsego County Jail. And 6616, you do have credit for 3 days served. 6617, credit for 102 days served. On file 6616, the court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a state cost of $68. 6617, a crime victim's assessment of $130 and a state cost of $68. You have the ability to seek an appeal of these sentences, and Mr. Kilo, can you?
I will, Your Honor. Thank you.
Is she sentenced to probation, Your Honor?
No.
Thank you, Your Honor.
Thank you.
Wait. She's got two different cases.
Oh, wait a minute.
We gave you 1-7, so it's equal to 6. Yep.
Now I've got a jail sheet.
All right, thanks, Judge.
Thank you.
Sorry about that.
That's okay.
Mr. Leach, are you there?
I am. Good morning, Your Honor.
Okay.
I'm having an issue
On the
with my
record.
video this morning.
Okay, that's all right. As long as we can hear you. We're on the record in People versus McNarney, case number 236507. We have Mr. Leach connected by Zoom. His client is also connected by Zoom. Mr. Rolla's here on behalf of the people in person. This is set for a status conference in this case today. We do have a trial date set for January 18th. Mr. Leach, this is the plea cutoff date. Does your client wish to proceed with trial as scheduled?
Yes, sir. We're ready to proceed with trial.
Okay. Mr. Rolla, are the people ready to proceed on the 18th?
We are, Judge.
Okay. All right, so we'll go forward as scheduled on January 18th. Is this set for 1 day or 2?
1 day trial, Judge. It's not very long. We have the same witnesses for both incidents.
We actually do have it set for 2 days.
Oh,
but
it is, oh,
if we don't need to, that's fine.
we may not, at most a day and a half, Judge, I think.
Okay. All right, so Mr. Roll, I'll just ask that you submit your proposed jury instructions and verdict form. Mr. Leach, you don't have to submit a full set of instructions, but once you receive the prosecutors, if you can just notify the court if you have any objections to any of his, or if you have any additional or modified instructions that you would like for the case, okay?
Yes, ma'am. Or yes, sir. Thank you.
All right, and then Mr. Leach, I just need you and your client to be here ready to go at 8:30 on the morning of trial. Mr. Leach, any issues we need to address for your side prior to trial today?
No, sir. I'm not sure what witness list. I think Mr. Gilo was the previous attorney who had sent over a witness list. I've got potentially 3 witnesses is all. So other than that, we're all set.
Okay, if you can submit the names of those witnesses to the court prior to the trial date, I read as part of the instructions the names of all the witnesses. So if you can just send me yours so that I know.
Yes, sir.
You're intending. Okay. Mr. Rolla, anything further on behalf of the people?
Just one thing for the record, Your Honor. I want the record to reflect that a plea offer to an added count 3 and 4 was extended to defense counsel back on the 15th. And that apparently offer had not been made to him, although it had been made to prior counsel. The information was not disclosed. That would have been 2 counts of assault for dismissal of the felonious assault. So that way there can be no question for any appellate record should we get there in the future.
Okay, Mr. Leach, is that accurate? Are you aware of that plea offer?
Yes, sir. We discussed that on the 15th, and based on my client and the descriptions of what happened with the 2 other witnesses, that's not going to be a possibility. But thank you.
Okay, that's fine. All right, so we'll proceed, starting at 8:30 in the morning of, January 18th. And Mr. Leach, you and your client are free to disconnect at this time.
Thank you, sir. We'll see you then.
Thank
Thank
you.
you, Mr. Rowland.
Thank you.
Sir, can you unmute? Thank you. Can you tell me your name?
Me?
Yes,
Jared Martin?
Mr. Martin. Okay. Mr. Martin, I'm just gonna put you on hold for, oh, no, your attorney's here, so just stay right there. Mr. Clagstad, do you need a minute? Sorry, we're ahead of schedule, but
I'm good to go,
your
Judge.
client to sign in. Okay. Okay, we'll go on the record in People versus Jared Martin, case number 236620. The record should reflect Mr. Martin is appearing today by Zoom. If I could have both counsel put your appearances on.
Record, Your Honor, Mike Rowland, behalf of the people.
Judge Mike Clagstad, P number 79314 on behalf of Mr. Martin.
Thank you. We're set for a scheduling conference. I think this is Mr. Martin's first appearance before the circuit court in this file. Mr. Clagstad, can you tell me where things are at from your side?
Judge, Mr. Martin obviously is still in inpatient residential treatment. My understanding is we don't have an update yet. I have spoken to Sheboygan County Treatment Court Administrator, which I think we're optimistic about. Her indication was they'll wait as long as they have to wait. It's not a rush from their perspective. That said, Judge, I do understand from your perspective that, you know, we'd like to get somewhere eventually. But if we're not trying the court's patience, I think I would just ask for another 30 days.
Mr. Rowland?
People don't have any objection in that regard, Judge, and I would indicate, of course, there was a plea offer made in this matter. Obviously, any final plea status conference would ask to be adjourned in conjunction with any delay of any trials.
We'll set this for a status conference in 30 days and go forward at that time. Mr. Clagstad, if you can just notify the court if your client is still in treatment so that we can have it set.
Very good.
You can appear by Zoom.
Fantastic.
Mr. Martin, if you're out of treatment by the date of that next hearing, we'll need you to appear in person though, okay?
Yes, Your Honor.
And then make sure you stay in touch with Mr. Clagstad so that you're ready to proceed at that next date.
Will do.
Mr. Clagstad, anything else we need to address today?
No, Your Honor. Thank you.
Mr. Rolla.
No, Your Honor, thank you.
Mr. Martin, did you have any questions at all?
No, I think I'm okay, Your Honor. Thank you.
Okay, that's all for today, and you are free to disconnect at this time.
Thank you.
Judge.
Our next hearing is set for 9:45, so we'll take a recess until that time. Mr. Killing, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in People versus Joshua Killing, case number 226418. The record should reflect Mr. Killing's presence today by video from Otsego County Jail. I think it had counsel put your appearances on.
Thank you, Your Honor. For the record, McLoud.
Thank you, Your Honor. Richard Truce, speaking on behalf of Mr. Killen.
Okay, the court set this for a status conference following mistrial earlier or late last month. Mr. Truce, can you tell me where you're at with this case today, please?
So, Your Honor, I did send a proposal to the prosecutor to potentially resolve it. I haven't heard anything back, although at the time I sent it, I'm not necessarily surprised by that. I did receive, I think, his motion, but not his brief yet in regards to the transcript. I anticipate that I'm likely going to be responding to that sometime this week. What I would suggest is, I don't know if we have a date for that motion, but I think that's probably going to be the next thing that needs to be determined is the admissibility of that. And obviously, the prosecutor and I are sure will continue to have discussions. And if we do have a resolution short of another trial, obviously we'll bring that to the court's attention.
Okay, Mr. Rowland.
And thank you, Your Honor. Mr. Truce indicated correctly. Our office did send over to him a motion for use of the appointment examination transcript and the cases that were going to be cited in the brief. I got it to him so he would know even prior to today that we're going to be filing it. I did so at the court's request. If the court recalled at the end of the last matter, I indicate on the record I would be doing so and be notifying the defense after I met with the victim and his mother. Having met with them last week, I then filed the motion and got a copy of Mr. Truce. We'll be filing our brief sometime this week. I imagine if it's going to take motion hearing, it may be 30 minutes.
Did you get a date for that motion yet?
I didn't yet. I wanted to get the brief done first, Judge, before I went and requested a date, so that way I would not be inconveniencing the court.
Right, so, I mean, I agree. I think that's the threshold issue going forward if this case is going to proceed to another trial. So, Mr. Rolla, I'll just ask that you get that motion filed and set for hearing. 30 days.
That's fine, Judge, not a problem.
And you said about a half an hour is what you think?
I think that's fair, because again, I think the law is the law. The facts are, there'll be some argument on that, but I think that the court will be making it as a legal decision.
Okay. Mr. Truce, do you have any objection to the court getting new dates for the trial? Whether we actually need them or not is one thing, but I think the sooner we can get the court scheduling that, if we do proceed to trial, that'll be.
Yeah, I have no objection to the court docketing dates. I mean, obviously this case has been around. I mean, I have to imagine this is one of the older ones on the court's docket at this point. Obviously, I would appreciate if the court were cognizant of the motion hearing that obviously has to happen before the trial.
Right. Okay. Mr. Rolla, any objection to the court getting this back on the trial calendar as quick as possible?
Obviously not, Judge. I think that would be appropriate under the circumstances.
Okay. So we'll say prosecutor file that motion within the next 30 days. The court will reset this for a 3-day jury trial at the next available date with the final status conference prior to the trial date. Mr. Truce, anything else we can address for your side today?
No, Your Honor, I think that's an appropriate way to proceed.
Okay, Mr. Rolla.
Nothing further. Thank you, Judge.
Mr. Killing, do you have any questions at all?
No, thank you.
Okay. All right, thank you. That's all for today. The court's going to go ahead and disconnect at this time. People versus Nathan Beebe, case number 236626.
Secretary, I call that people.
Thank you, Richard Truce, on behalf of Mr. Beebe.
The date and time set for sentencing in this matter. The record should reflect Mr. Beebe's present here in the courtroom today. Mr. Beebe, have you had a chance to go through the pre-sentence report and talk to Mr. Truce about that?
Yes.
Mr. Church, are there any additions, deletions, or corrections?
No,
Or any challenges in the scoring of the guidelines?
no, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections to the guidelines. No additions, deletions, or corrections, that's the body report, no changes as to the score, only guidelines.
On behalf of the people for allocution.
Just briefly, Judge, this is a second felony arrest while the defendant was on probation. It's his third felony overall. It's possession of methamphetamines. I think some jail should be imposed. The amount of that obviously is discretionary. Thank you.
Mr. Church.
Thank you, Your Honor. On the face of this, Mr. Beebe's history looks pretty bad. But when you actually start to take a look at what the offenses that he's convicted of are, I think it paints a slightly different picture. So again, the PSI indicates that he has 6 prior misdemeanors. The misdemeanors include a noise ordinance violation, failure to stop after an accident, theft of fuel, plate violations, and operating without insurance. Frankly, none of which I think are probably of particular concern to the court. He has 2 prior felonies. One of the prior felonies is a larceny offense, which occurred almost 12 years ago. And then there's the more recent felony offense, which is a 2020 controlled substance offense out of Texas. My client indicates to me that that controlled substance offense in Texas is marijuana related. Admittedly, the PSI doesn't really give you much information other than just saying that it's a controlled substance offense out of Texas. So when you really start to break down his prior history, the reality is I don't think that it paints the same picture that on paper when you say this is his 3rd felony and he has 6 prior misdemeanors that might bring to the court. I think it's also important to look at what Mr. Beebe has done since this offense happened. And this has caused him to sort of relook at a lot of things in his life. And he started substance abuse counseling, and I have a letter that I'll present to the court from his counselor, but he's engaged in substance abuse counseling. He has started anger management counseling. The court may recall part of the plea deal here was resolving a misdemeanor matter as well. So he started the anger management counseling. He secured employment that he's actually supposed to start later this afternoon at, I believe, is it Dollar General? At Dollar General. He secured appropriate housing. Family Dollar. He secured appropriate housing. Frankly, he's addressed a lot of the issues that sort of, bring him down this road. The guidelines range here really vest the court with the most amount of discretion it can possibly have. Really everything is available as a tool to what I would really suggest to the court though is what's the end goal here, and I think the end goal here is rehabilitation to get Mr. Beebe to address the issues that bring him here, which again the recent history would suggest substance abuse. I think he's doing that. I think any kind of lengthy incarceration really just runs the risk of setting him back. That's going to cost him his job. It's going to cost him the housing that he's secured. And while, it's not going to stop him from the counseling, it is going to interrupt the counseling that he's already got in progress. We'd have to reestablish and restart that. So I would suggest to the court, given the guidelines range, given his prior history and those things, that I would tend to agree with the prosecutor that there's probably some jail appropriate. I would suggest to the court holding that in abeyance and seeing if he continues on this path that he's on, continues doing the right things. If he doesn't, well, then the jail's right there. If he does, then, we get the ultimate outcome, which is, returning a family member to our community, a brother, a father, or a son. Thank you.
Thank you, Mr. Beebe. Anything you wanted to say?
I think you pretty much covered it there. That literally covered everything.
right, Mr. Beebe, I've had a chance to review the pre-sentence report prior to the hearing today. So familiar with all the information in that report of the offense that brings you before the court today, as well as your past history and background. Take all of that into consideration along with what the lawyers had to say, and I did have a chance to read this letter from your counselor just now. And yeah, I mean, I think there certainly is potential for improvement. I think there's certainly some issues that you're still facing, it sounds like, with regard to probation in Texas, and you may have some penalties to face for that at some point based on this case. And that is obviously concerning to the court when you're already on probation in a different state and you're here in Michigan committing crime. So I think there needs to be an element of punishment here and deterrence. I think it should be at the low end of the guidelines. I don't have an objection to you participating in the work camp program through our jail, which would allow you to maintain your employment and give you an opportunity to do the things that Mr. Trush has indicated here today, to continue with your counseling and hopefully get some tools to help you move forward from this. And to the extent that you don't do those things, then rather than being out in the work camp program, you would have to serve the time in the jail. But I think there needs to be a consequence here, particularly given your circumstances under supervision at the time that this occurred. As Mr. Trush indicated, the guidelines go from 0 to 17. So yeah, the court has the option of no jail time, anything from 0 to 12 months of jail, or even prison. As I indicated, I think a sentence at the lower end of the guidelines is reasonable and would account for your conduct in this case, as well as the fact that you were on probation when this occurred. The court is going to sentence you to 90 days in the Otsego County Jail. You do have credit for 5 days served. Court has no objection to your immediate release to work camp, since you do have a job. The court is going to impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, and estate costs of $68. You have the ability to seek an appeal of the sentence. Mr. Trush, if you can just let me know once Mr. Beebe's acknowledged his appellate rights. Right, Mr. McLoud, are you able to hear me okay?
Yes.
Make sure everything is taken care of, please.
All right, we'll go on the record in People versus Raymond McLoud. This is case number 236616. The record should reflect Mr. McLoud is present today by video from Crawford County Jail. If you have counsel, put your appearances on.
The record, John, I don't have people.
Thank you, Your Honor. Richard Trush on behalf of Mr. McLoud.
Okay, this is set for a status conference in this case today. Mr. McLoud failed to appear for a hearing back in November for the reason that he indicated he had COVID, I believe, at the time. So the court set this for a show cause hearing. Obviously, Mr. Was then arrested at something subsequent to that because he's lodged in Crawford. So Mr. Trush, can you give us an update about where things are at with this case and how you want to proceed today?
Yes, Your Honor. So everything the court has indicated so far is accurate. Mr. McLoud did become incarcerated over in Crawford County. I do represent him on that matter. It's a felony matter over there. Insofar as, and I'm somewhat unclear, Mr. McLoud indicates that he thinks his bond here has already been canceled, but I asked him insofar as it's not been canceled at this point, that it be canceled.
And then how do you want to go forward today in terms of proceeding with the case?
So, Your Honor, I think we're going to have a global resolution of both the matter in Crawford County and the matter here. I've been in discussions with the prosecutor. I sent out sort of a written proposal to him. It was late last week. I don't recall if it was either Thursday or Friday. We talked about it a little bit. I think he was reviewing that. I would suggest 30 days would be appropriate. We'll likely be back here at that time, either with a deal in place or ready to docket the matter for a trial.
Okay, Mr. Rolla?
That's correct, Your Honor. Again, we have no objection to the court obviously canceling bonds, so we can give credit for his time served. That motion has been made before the court. I don't think it has been canceled yet, to my knowledge.
Okay, so the court will set this for a plea hearing, status conference in 30 days. The court will order that Mr. McLeod's bond be canceled. Mr. Trush, if you can just submit an order to the court for signing to reflect that as of today's date, so that we have that in file. So we have the proper paperwork. And then we'll proceed in 30 days. Mr. Trush, anything else we can address for your side today?
No, Your Honor, I appreciate the court giving us the additional 30 days.
And then the court will dismiss the show cause as well. Mr. Rolla, anything further on this file today?
All right, thank you.
Mr. McLeod, did you have any questions at all?
No, Your Honor.
Okay, thank you. That's all for today, and the court's going to disconnect at this time. Mr. Fragel, are you able to hear me okay?
Yes, I can, Your Honor.
All right, we're on the record in People versus Sanders, case number 236622. Record should reflect Mr. Sanders is present here in the courtroom today. Mr. Fragel's here on his behalf by Zoom. Mr. Roll is here on behalf of the people in person. Mr. Sanders, have you had a chance to go through the pre-sentence report and talk to Mr. Fragel about that?
Yes, sir.
Mr. Fragel, are there any additions, deletions, or corrections that need to be made to that report?
Just one small correction, Your Honor, on CFJ 284, page 6, under employment. Link, tool, and die should be from 1990 with the same end date. Start date being 1990.
All right, Mr. Roll, any objection to that change?
Not at all, thank you.
Okay, any other corrections, Mr. Fragel?
No, thank you.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections to the body report or challenges to the guidelines.
Anything on behalf of the people for allocution?
Briefly, Judge, it's a situation where the defendant was traveling on I-75 going all over the road at 94 miles an hour and was apparently at blood alcohol content 0.24, more than triple the legal limit. We're just fortunate that we're not here in more tragic circumstances. I hope that whatever sentence the court imposes, that the defendant recognizes he has to do something about his substance abuse issues before he kills himself or somebody else. Thank you, Judge.
Thank you. Mr. Fragel, anything on behalf of your client today?
Yes, Your Honor. Mr. Sanders has a 7th or 8th grade education and has led an otherwise very productive life. He was a Marine. He got out of the Marines and he worked 30 years as a tool and die man without incident. He lives with an older couple who he helps in their day-to-day needs. So he's got a good heart. He just also has an alcohol problem, and he has, since this incident, engaged the VA facility with. He's opened an account, and they're waiting for him to get finished with sentencing to determine what type of programming to put him into. And he does have a few health problems that seem to be budding that he's also concerned about, and I think the VA will help him with that. So given that he's aware he's got a problem and he's struggled a bit with the PBTs, and I told him, I said, you understand you have to make sure those come up as zeros, period, no excuse. And he's beginning to realize that as well. He did have 2 violations over the last 4 or 5 months. But the distance between his convictions as well, Your Honor, were I think on 2 occasions over 10 or 15 years. The last one was 10 years ago. So for those reasons, I would ask the court to give him the minimum jail sentence of 30 days and have a firm supervisory involvement to get him into the VA program to keep him sober. Thank you.
Thank you. Mr. Sanders, anything that you wanted to say today?
Yes, sir. Want to say that I am very deeply sorry that I did what I did, and I'm very lucky that I didn't hurt anybody, and I'm glad I didn't hurt anybody. But I'm trying to do the best I can. I'm trying to get into rehab and all that good stuff through the VA. I just got enrolled in it. I couldn't get started with anything because my first primary visit was the 20th of November, which I had to be here. And then the 28th is fine when I finally got my primary. I do have a letter from the counselor and the AA from the VA stating that I am seeking help through them. So, yeah.
Okay. All right. I did read through the report. I'm familiar with what happened in this particular case. And then there's information in that report about your background and your circumstances. And this is a really frightening incident. I think about my kids, my family, my friends out on the road. At the same time that you're out there with a 0.24 blood alcohol, driving like a madman on I-75, it's scary to think what could have happened while you were on the road that night. And it is really fortunate that no one was in your path and that you didn't hurt yourself either. So the court has a very vested interest in deterring the kind of conduct that you engaged in. And there needs to be a level of punishment for that so that you understand that that is just not acceptable and that other people understand it's not acceptable to do that because of the danger that you present to yourself and everybody else, all the other innocent people just out going about their day or their evening. And so I think that needs to be a component here, but I also think that there's potential for some rehabilitation. I think the services that you're seeking out could be very helpful to you. And so I think a term of probation is also important to make sure that you're following through with those kind of things so that you don't get yourself in a position where you are putting other people or yourself in harm's way. So I think it's an appropriate recommendation generally. The guidelines here are 0 to 6 months. I think a sentence right in the middle of the guidelines adequately addresses the wrongfulness of your conduct. But also recognizes some of the mitigating factors. And I think, as I said, probation is really important in particular to make sure that you're following through and that you're not using alcohol while you're on probation. So the court is going to place you on probation for a period of 24 months. The court is going to adopt as the conditions of that probation all the terms and conditions in this report. Most important of which, of course, is that you not use or possess any alcoholic beverages or any other intoxicating substances. The court is going to order that you serve 90 days in the Otsego County Jail. You do have credit for 2 days served. That you pay a crime victims assessment of $130, court costs of $325. Mr. Fragel, you're retained, is that correct?
Yes, Your Honor.
Okay. A $200 OUIL testing reimbursement fee, a DNA testing fee of $60, a state cost of $68, and a supervision fee of $30 per month while you're on probation. You have the ability to appeal this sentence. We're going to provide you with some papers standards that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. And that's what the officers can be giving you here in a second.
Or I believe it's part of vehicle mobilization.
And that's that. Yes, the court will require vehicle mobilization as well.
Thank you, Your Honor.
Mr. Roll, anything else you need to address for the record today?
Not on the record, not on the application.
Mr. Fragel?
Nothing further. Thank you.
Mr. Sanders, you're remanded to the custody of the county. I ran out of sheets.
That's fine.
Okay. The court's next hearing is set for 11 a.m. Court will be in recess until then.
I'm gonna go round up some of your pre-treatments. I'll be back soon.
Okay.
All right, we've got somebody joining us on the phone. The last four digits are 5111. Can you tell me your name, please?
Barbara Stockman.
Ms. Stockman, okay. All right, and then let's see, on the Samsung device, can you tell me your name, sir?
Kevin Reed with Mark Sadecki, Your Honor.
Okay, thank you. All right, we have Mr. Sadecki connected as well, so we'll go on the record. This is Kevin Reed Development versus Barbara Stockman and Alan Jackson. This is case number 23-19315. We have all parties, with the exception of Mr. Jackson, connected today by video. Mr. Sadecki, this is your motion for entry of a default judgment. I did receive your motion and the supporting documents. I've had a chance to review those prior to the hearing today. Is there anything that you wanted to state for the record in support of that motion?
Your Honor, I would rely on the motion and brief along with the exhibits, but to the extent Your Honor would grant us a few minutes, I'd like to, if possible, meet in a waiting room with Ms. Stockman and see if we could agree on some terms for a settlement, and then come back out on the record and state those on the record, and also have you rule on the motion for entry of default judgment.
Okay, yep, I can do that. I will create a breakout room. So Ms. Stockman, you're going to go into a breakout room so you can have a discussion with Mr. Sadecki, okay?
Okay.
And then Mr. Sadecki, did you want me to include your client in that as well?
Please, Your Honor.
Okay. Okay, I'm opening that room right now.
Thank you, Your Honor. and it'll take you.
Hello?
Okay, you're back,
Hello, Ms.
Barb. I'm
Stockman.
just waiting.
Okay, we've got Ms. Stockman back. We have Mr. Sadecki back, his client. So Mr. Sadecki, how did you want to proceed?
Here's how we'd like to proceed, Your Honor. We've reached an agreement verbally that's not been memorialized to writing, but I'd like to place it on the record to the extent we're on the record now.
Okay, go right ahead.
What the parties have agreed to, Your Honor, is we're going to move forward with the motion. Barbara Stockman, as the one defendant, has agreed to entry of the proposed order that will allow her to execute a quitclaim deed conveying the property back to, or actually it's going to have to be done by warranty deed. Here's the essence of the agreement, Your Honor. Rather than have the court move forward on this motion for entry of default judgment and then wait to take further action, Ms. Stockman is going to deed the property out to the plaintiff. Then the plaintiff is going to sell it and then pay the costs associated with marketing and selling the property. There is also an individual that lives there, Alan Jackson, and or his son. Plaintiff will take responsibility for notifying the occupant of the home that is subject to a month-to-month rental agreement that we're gonna terminate that tenancy and sell the property. Plaintiff Kevin Reed Development will sell it, keep track of the costs associated with the sale, and the parties have agreed, the parties being Barbara Stockman and the plaintiff, that plaintiff Kevin Reed Development will accept $70,000 to satisfy the judgment, even though the judgment is substantially greater than that. We will keep track of the costs and attorney fees, which should be minimal to sell the property. The primary costs are going to be securing title from Ms. Stockman in the form of a warranty deed to Kevin Reed Development. That's where the order comes in, Your Honor, because we have to enter an order voiding the prior transfer so that the title examiner, when he or she looks at the property, will know that that was a fraudulent conveyance and it's been set aside and of no legal force or effect. So the order will enter, granting the motion for entry of default judgment with all the relief requested. Ms. Stockman has agreed to that. She's also agreed to accept $70,000, or strike that. Kevin Reed has agreed to accept $70,000 in lieu of the actual damage amount. And then any surplus funds after costs and expenses are paid by Kevin Reed Development will be tendered to Mrs. Stockman. Now, one of the things I want to place on the record, Your Honor, is Ms. Stockman, you want to tell the court where you're at right now currently, because that has an effect on this proceeding in your decision, and I want to make sure that you are knowingly and voluntarily and willfully agreeing to this.
I'm in Traverse City at the infusion clinic getting ready to start chemotherapy. I have not had any infusions yet, so I'm perfectly of sound mind.
Okay, thank you. And Ms. Stock, have you been able to hear everything that Mr. Sadecki has said so far?
Yes.
Okay, and do you agree? Are you in agreement with that resolution?
Yes. Yes, I am.
Oh. All right, thank you, Mr. Sadecki.
Okay, I want to go over the judgment with her, Your Honor, if I may.
Yes.
second, Your Honor, I have to grab my glasses. So Ms. Stockman, you understand that if the court grants plaintiff's motion today, that the transfer of the property from yourself to Alan Jackson will be set aside and declared to be null and void. You understand that?
Yes,
Okay. And that you've also agreed as part of a settlement with plaintiff Kevin Reed Development that you will convey the property to Kevin Reed Development, the property commonly known as Lot 11 of Gaylord Mobile Home Estates, having a tax ID number of 69113100000011-00, to Kevin Reed Development pursuant to a warranty deed, the costs of which will be paid by Kevin Reed Development and then taken as a set-off when the property is sold. Because the goal here is to get Kevin Reed Development the sum of $70,000 net to satisfy the judgment currently due and owing from you. And then any monies after the expenditure of all costs, attorney fees, and expenses over and above the $70,000 plus the cost, attorney fees, and expenses will be paid to you once the property is sold. You understand that?
yes.
Okay. And one other thing, Your Honor, I did speak with a sheriff deputy, Scott Hope, who does have a levy interest in this particular piece of real property. He told me last week that I may move forward, and he and I, on behalf of the plaintiff, will resolve the costs associated with that levy, which he believes were less than $1,000. He will be sending me an invoice for that. My office will be paying that bill, and then that levy will be discharged. So I will be modifying this judgment slightly to address what I've stated on the record, and then we'll submit it to Your Honor for your review, execution, and entry with the court. The only other question I have for the court, Your Honor, is are orders still being submitted through the mail, or may I email the order to the court?
Yeah.
We, at this point, we still need you to submit those by regular mail.
Okay, I'll submit it by first class mail then.
Okay, so just to kind of recap and to make sure we have everything for the record, Ms. Stockman, again, even though you're at a facility to undergo some treatment for cancer, at this point this morning, you feel that you're of sound mind and able to make decisions relative to this case?
Yes,
Okay, and you've heard everything that Mr. Sadecki has stated with regard to the agreement?
yes,
Okay, and you are asking the court to proceed with that agreement and to make that final by signing a judgment when Mr. Sadecki prepares that?
yes.
Okay, all right, thank you. So Mr. Sadecki, the court will just look for that revised order once that's been presented, and then the court will sign that.
Okay, one point of clarification, Your Honor. I will be sending 2 documents to Ms. Stockman via email, and then ask her to do electronic signature or scan and email it back to me to expedite this matter. The first will be the stipulation that's attached to my motion as Exhibit 10, and then the second document will be the revised judgment, which I will send out today via email to Ms. Stockman for her signature. And as soon as I get her signatures back on those documents, I will submit the order via first class mail or priority mail to Your Honor's court for entry and subsequent recording.
Okay, very good, thank you. Mr. Sadecki, anything else that you needed to state for the record today?
Just that the order, once we get it back, it'll be recorded with the Register of Deeds to correct that title deficiency, to allow the property to be sold, and that should take care of it, Your Honor.
All right, thank you. Ms. Stockman, did you have any questions?
No.
Okay. All right, thank you. That's all we have for the record today. All parties in this case are free to disconnect.
Thank you,
Thank you
Your
very
Honor.
much.
Thank you, Your Honor.
That also concludes the court's morning docket. The court will be in recess until 1:30.